And I give the call to the member for Werriwa.
Thank you, Deputy Speaker. I rise to make my contribution to the Fair Work Legislation Amendment Closing Loopholes Bill 2023. Article 23 of the United Nations Universal Declaration of Human Rights deals with employment and workplaces. The article states that everyone has the right to just and favourable conditions of work. Article 23 then goes on to add that everyone has a right to equal pay for equal work and just and favourable remuneration and the right to form and join trade unions. I know that scares those opposite, but it is there. Australia was one of only 8 nations involved in the drafting of the declaration. Both Dr H.V. Evatt and Fred Whitlam, the father of my predecessor in Werriwa, were actively involved in drafting the document. Importantly, Australia committed itself to the document at the earliest opportunity by being an original signatory in 1948. These points are important, Deputy Speaker, because the bill before us today adds further layers to our country's commitment to those original principles espoused all those years ago. Because workplace rights are just that. They are rights. They are just not rights for some. They should be universal, and those rights need constant attention. This country has seen in recent years any number of attacks on workers and their rights. Who could forget worse choices in 2005? Certainly not the workers of this country. Their rights to collective bargaining, protection from unfair dismissal were severely threatened and curtailed. And certainly not the unions. Their power to protect the rights of their members was similarly threatened to the point of extinction. Thankfully, the Australian public completely rejected the extremist work choice agenda. At the ensuing federal election in 2007, the then Prime Minister not only lost government but his seat. It was a devastating indictment of a leader in a government that went too far, way too far. But it was equally an emphatic demonstration that the Australian public want workplace protections. They want to be treated fairly and respectfully in the workplace. In short, they don't want to be ripped off. Those of us on this side of the chamber have always known this. Protecting the worker and their rights isn't something we pay lip service to. It isn't something we just note then file away. On the contrary, it's something we passionately believe in, and that's why I'm delighted to speak on this bill today. Because this bill, in a very real way, builds on the spirit and the essence of Article 23. Back then, just after the war, workplaces were so very different. There weren't gig workers or a gig economy, and casual work was nowhere as common as it is now. So this bill is timely, the way all good legislation is. That is, it addresses very real and contemporary issues, and the changes it seeks to bring forward are not radical. They are necessary and are changes that I think those who drafted Article 23 would agree with. Deputy Speaker, the legislation before the House today will implement the next tranche of industrial relations reform and implement the policies that the Albanese Government took to the last election. And you know what? We won that election. This legislation will strengthen workers' rights and ensure Australians can continue to seek well-paid and secure work. We've seen the continued rise of casualisation, and while some employees enjoy the flexibility, this is not always the case. Many Australians are classified as casuals, yet work the same number of hours as full-time employees, but without job security and entitlements afforded to full-time employees. This bill will legislate a new, fair and objective definition of what it means to be a casual employee and provide workers with 2 pathways to change their status. The first through the employee choice pathway that allows casual employees to notify their employer that they believe their status has changed. The second through the existing casual conversion pathway, an obligation on large and medium employers to assess all their casuals and offer them conversion if they have a regular work pattern and 12 months of service. Importantly, the changes are about choice. The choice for casual workers who work regular hours to convert to a more secure classification should they wish, but also the choice to say no should they wish to stay casual. These new pathways require active and conscious decisions. No one will be forced to convert. The new framework will support more Australians to move into secure work because they deserve to have the certainty and entitlements that help them plan their lives. Employers will be able to seek reclassification under the new pathway 6 months from the 1st of July 2024 or 12 months from the 1st of July 2024 if they are employed by a small business. The second major reform in this bill relates to labour hire. Labour hire plays an important role in many industries, providing surge in specialist workforces. However, there is a glaring flaw with the current system, a loophole that undermines the pay and conditions of workers, and that is the use of labour hire to undercut and undermine enterprise agreements between a workforce and their employer, using a labour hire workforce that is paid and are entitled to less than the current workers. It is a loophole that undermines workers and undermines the simple principle that workers should be paid the same amount for the same job. This is the loophole this bill seeks to close. It empowers Fair Work Commission to order that labour hire employees be paid the same wages as an existing enterprise agreement covering their employer in circumstances which are fair and reasonable. From royal assent of this bill, employers, employees and unions can make applications to the Fair Work Commission for such an order to be made should they believe the circumstances are warranted. And for the 1st of November 2024, the orders become enforceable. If you work the same job, you should get the same pay as your colleagues. It's that simple. It's an extension of the fair and egalitarian society that we believe Australia is. The third major reform in this bill relates to the gig economy. The gig economy has been on the rise for several years, and whilst it's brought with it flexibility for both consumers and workers, it's unfortunately lowered workplace rights that many of us take for granted. The gig economy is part of our economy now, and as such should be subject to the regulations that protect workers both from exploitation and harm. Since 2017, 14 workers have lost their lives in the transport gig economy, and unfortunately that number may be a low estimate. Each worker has a right to be safe at work, to be able to come home safely at the end of the day, no matter what your employment status is. We know that there is a direct link between low rates of pay and safety. It leads to workers taking risks as they try and make ends meet. Workers in the gig economy, just like all workers, deserve minimum pay and conditions. Australia is not the US. We will not become a nation that forces our lowest paid in society to rely on tips to survive. The measures in this bill will strengthen the powers of the Fair Work Commission, giving them ability to set minimum standards for employer-like independent contractors that work in the gig economy. It will allow employer-like collective agreements between employee-like workers to come to an agreement with digital labour platforms. It will protect workers against unfair deactivation and extend protections that already cover employees to cover employee-like workers. Because workers in the gig economy deserve minimum standards, they deserve to get home safely and they deserve fair pay. This bill will also introduce similar measures in the road transport industry. Much like the gig economy, workers in the transport industry are in a race to the bottom, creating an environment for unsafe and unsustainable practices. An environment that leads to unsafe work practices goes against the hard work of thousands of workers who have fought for better conditions, not just here in Australia but across the world. The Fair Work Commission will now be empowered to set a minimum standard in the road transport industry, a key measure proposed at last year's Jobs and Skills Summit. To ensure that the Fair Work Commission is adequately advised on minimum standards, an expert panel on road transport industry will be established within the Commission. It will be comprised of people with expertise and contractors or businesses that represent road transport industry. Similar to the measures introduced for gig economy workers, a new collective agreement-making framework will be created, allowing workers to negotiate better pays and conditions. Eligible contractors will also gain protections against unfair contract terminations and can apply to the Commission to seek a remedy. This bill also introduces an industrial manslaughter offence in the Work Health and Safety Act 2011 and increases penalties because, again, being safe at work is a right. It is the expectation of all workplaces to provide a safe work environment, and breaching work health and safety duties should carry serious and significant penalties. The new offence...
I'm just going to need to interrupt. It's 4:30 p.m. and I propose the question that the House do now adjourn. And I'm giving...
And I call the honourable member for Werriwa.
Thank you, Deputy Speaker. In continuation, the new offence will carry with it penalties of $18 million for body corporates and 25 years for individuals. Other penalties will significantly increase to reflect the seriousness of the safety breaches. Recklessly exposing an individual to a serious injury or death, a Category 1 offence, will now carry a penalty of $15 million for body corporates and up from $3 million. Individuals face a $3 million fine, up from $600,000, and a $1.5 million fine for any other person. All other penalties in the WHS Act will increase by 39.03% and will be indexed to the CPI. A safe working environment is a right, and these increased penalties reflect the seriousness of violating that right. Other measures in this bill that will improve and strengthen worker safety, both inside and outside of the workplace, include extending the functions of the Asbestos Safety and Eradication Agency to address silica-related diseases, improving access to workplaces by workplace delegates for safety and compliance issues, and making it unlawful to discriminate against any employee who is or was subject to family or domestic violence. Speaker, another significant measure in this bill is the criminalisation of wage theft. No longer can employers intentionally steal from the pay packets of their workers without serious consequences. Intentional underpayment will become a criminal offence with a maximum of 10 years imprisonment or a maximum fine of either 3 times the amount underpaid or $1,565,000 for an individual or $7,825,000 for the body corporate, whichever is greater. This government is serious about protecting the wages of Australians, and these significant penalties reflect that. Wage theft is theft, and it's time to be treated as such. Unfortunately, there's not enough time to mention every measure contained in this bill that will improve the rights of workers. This includes measures that will protect workers against sham contracts, streamline workers' compensation claims for first responders who sustain PTSD, improving worker access to enterprise agreements and strengthening the powers of the Fair Work Commission. The bill is a culmination of more than a year of consultation from across the Australian economy and is a continuation of our commitment as a government to protect and strengthen the rights of workers. That was the Albanese Labor Government's election commitment, and it's what good Labor governments do. I'm honoured to speak on this bill and commend the bill to the House.